Well, good afternoon, everybody, and welcome to the Samfiru Tumarkin live employment law show. My name is Sandy Chen. I'm an employment lawyer at our firm's Vancouver office. I'm here for the next half an hour or so, and I'm here to answer questions. Questions live from you, anything and everything to do with employment law, disability law, if you're having issues with a coworker, issues of harassment and bullying in the workplace, or if you've got a new employment contract, anything and everything to do with the workplace. Please feel free to type in your questions, and then I'll be able to see it in front of the box in front of me. I can't see anybody, but hopefully everybody can see and hear me okay. But like I said, please ask anything and everything to do with employment law. A lot of the more recent issues I've seen it come across my desk are more. There's some interesting ones. We've got people being called back to the office from remote work. We've got cases of discrimination. I've come across a case recently where the person I was speaking to was working remotely for about 3 years now, and the company has finally decided to call them back to the office. And the question that was put to me was, is there a right to remote work? I'm not sure if anybody out there is kind of encountering this issue, and it's obviously quite an interesting question because remote work is fairly new to our world. We've got It's been 3.5 years almost since COVID, but the remote work issue I think can be broken down into kind of a contractual issue, right? An employment relationship is a contract, and the remote work issue, you have to look at the explicit and the implicit terms in the employment agreement. So I've seen that issue come up more and more as companies are kind of recalling everybody back to the office now. We've seen big company, well, Tesla did it last year, I believe. Amazon's doing it recently. A lot of the tech companies are doing it. A lot of the big retailers, the corporate offices are doing it, and so it's an interesting issue. I don't think it's been defined well. The case hasn't been across any Canadian courts, as far as I'm aware. But I think if anybody's dealing with that issue, feel free to come chat with me about it, or ask, or give me some, or ask here if you want. We've got a question here. Our first question. We got a question from JX2. As you understand it, employers to give a meal break after 5 hours of work. In the event that doesn't happen, what obligation of compensation is owed to the employee that is still on the clock? JX2, there's, the hours of work and the meal breaks vary province by province. Each, BC might be different than Manitoba, and that's just because employment generally, most people are provincially regulated, right? If they don't give you a meal break, you can make a complaint to the Employment Standards Board, right? And what each province has one, and you'll either be, the employer might be penalized for breaching the Employment Standards Act, and you could get the wages that you're owed, right? Because you have to work through your break. Or you could get either wages you're owed, or you take that break, a paid break, I assume, on another day, kind of like a banked overtime. But yeah, there's certainly remedies for an employer not complying with their legal obligations. Got another question here from MP. Is there anything you can briefly talk to about staff working out of a basement of a building in Ontario? Anything that generically covers that topic from the lens of employment law? MP, maybe if you could be a bit more specific. I don't see, in terms of just staff working out of a basement, I don't see any issues with that. One topic that may come to mind is kind of workplace safety, right? Um, hopefully the basement meets building codes and safety standards. But I think from an employment law perspective, there's nothing intrinsically, bad or illegal about having staff work out of a basement. Assuming that basement meets, has ventilation and all that stuff, and it's not a dangerous basement, if that's what we're talking about. But maybe you could be a bit more specific of what the concern is or what the issue is of these people working in the basement, and I can try to give you more information on that. And that goes for anybody. If my answer doesn't answer your question, or if I've missed it, please feel free to follow up, and I'll do my best. All right, we got more questions here. Got a question from Sam. Do nonprofit organizations have to pay severance if they let go of employees? So Sam, the short answer is yes. There's nothing that distinguishes, from a severance perspective, nothing that distinguishes nonprofit organizations from for-profit organizations. Obviously, there's always nuances. In BC, there's I know under certain legislation, the nonprofits may have more protection when it comes to other respects other than severance, right? So, for example, the one I can think of, directors of a nonprofit may be shielded from liability from certain employment obligations, right? That's just one example. But there's nothing distinguishing nonprofit and for-profit organizations in terms of severance. The big if the nonprofit organization is unionized, that could affect their severance entitlements, right? People who are non-unionized are governed by what's typically called common law entitlements, or their contract. And those severance entitlements, they could be a few months, they could be 24, 25, 26 months, right? And I'm sure most people watching probably know that it depends on certain factors like age, length of service, how senior your position was. The unionized employees, typically severance is governed by the collective agreement, if any, right? Because unionized employees have cause protection. So short answer, Sam, is yes, they have to pay severance. Okay, we got a question from MW on YouTube. You're dealing with a very difficult manager. You're waiting to speak with another HR person about this. Do you have any suggestions on how to handle this? Yes, I think that the first step you took is correct. You want to speak to HR about it. You want to kind of outline to HR. It can be verbal. It can be or you can submit something in writing. My suggestion to you is, whatever, if it's a verbal conversation that you have with HR, make sure you put your complaints in writing. Okay. Outline your complaints in writing and keep a copy of that just in case. It's just because I've seen this happen. But just in case, the company tries to say you never made a complaint. So I would make that complaint, participate. They're all, if it's a bullying and harassment complaint, which it sounds like it is, the company has an obligation to investigate that, right? And participate in the investigation, obviously. HR might interview you. They'll probably interview your manager and then come to a conclusion. But my general advice to you is try to, in terms of any conversations with the HR, any interviews, take notes, right? Take notes and get stuff in writing. Okay. So JX2, you're following up. You're in BC. Okay. One place you work is unionized. I gotcha. And then the overtime rate until a meal break. But the place you worked last night, you did 7 hours straight. Yeah. So JX2, I mean, if you're unionized, well, obviously different rules apply in the collective agreement. If you're, I'm assuming we're talking about the non-union job. You're saying you did 7 hours straight. There are certain exemptions under the ESA for meal breaks. I don't know all of them off the top of my head, but assuming you don't fall under an exemption, right? This could be something that I would address with the employer first and say, hey, this is actually a breach of the Employment Standards Act in BC. If they refuse to do anything about it, you can file a complaint with the Employment Standards Board, right? And not only might they provide you with compensation, they might also penalize the employer, the company, right, for not following the guidelines of, sorry, not guidelines, the law of the Employment Standards Act. Okay, so we got a follow-up here from MP. So MP, you were asking about the basement building in Ontario. Can staff refuse to work out of a basement on the original employment agreement and workspace agreement? So MP, yeah, I assume you're asking from the perspective of an employer. Can they refuse? So there's a few. Let's talk about the few cases where an employee can refuse, because it's unfortunately not a black and white answer. They can refuse if it's unsafe, right? We've covered that, and you've said it's totally legal, right? It's a safe workplace, ventilation, all that stuff. If one of your staff has a contract that says their place of work is 123 Main Street, right? And then you move them to another location 2 hours away, right? That's probably illegal. You can't do that if their contract says they're going to report to this place at work. My question for you is, how far away is this basement from their original workplace? What is their concern about the basement? And is this on a temporary basis? If your employment contract with the staff says you're going to work out of this basement at 123 Main Street, right? Then the issue ends there, right? They have to go to that workplace. I assume that something's changed recently where they have to work out of this basement on a temporary basis. So what's the reason behind that, and how far is it away from the original workplace? Other than those two general exceptions, you have a right to kind of dictate where your staff works, right? They can't refuse because it's a basement. There's no, view of the water, or, the space is cramped. As long as it's a safe, legal workplace, it's you have discretion, subject to that, how far is this away from their original workplace issue. Okay, so MP, you're saying it's the same building. Yeah, I mean, what's my question for you is, I don't see anything of why you can't, demand that they work demand that they work in the basement. My question for you is, what's the issue, right? Is it just because it's in the basement? I can see a case where, and I'm kind of thinking out loud, but I can see a case where if you're like the CFO of a company and he has an office on the 26th floor, right? And then you put him down in the basement with nobody else. I mean, that could be potentially a breach of his employment contract, right? But you're going to have to give me a bit more detail here. I don't understand why. I mean, is it on a temporary basis? What's the concern from the staff about working in this basement? Okay, we got a question here from Serena on YouTube. She says, how long do you have to be off work before you can claim long LTD, which I assume means long-term disability? So that's a good question, Serena. It's, it depends well, let me back up a bit. Long-term disability, you can have it through a private policy, which you go to an insurance company, you buy, right? And then that'll be your contract with the insurance company. Most of the times, from what I've seen, long-term disability is through work, right? Your company, your employer negotiates a policy with an insurance company, and that policy, will be 100 pages long, and you really have no control over that, right? Because it's your employer that's negotiating it. You might pay the premiums, but you don't really have control over that policy. So in that policy, whether it's through your employer or you bought it privately, there'll be something in there called an elimination period. And the elimination period, I've seen it could be 0 days, it could be 3 months, it could be 6 months, right? That dictates how long you have to be off work before you can claim a long-term disability. So, it's different. It's obviously each policy is different. It's case by case. There's not really a general rule of thumb, but if you're off, I've seen the highest I've seen is probably 6 or 8 or maybe 10 months. Hopefully that gives you a kind of a general sense, but I would get a copy of the policy and look at the elimination period. And obviously, Sarah, you have to satisfy the definition of disability under the policy, which you have to medically prove that, or prove with medical documentation that you are unable to do your job. And a question here from Tonya: if the employer says you were overpaid from a year ago, can they discipline you? The short answer I have, Tonya, is no. I assume that they have asked you for the money back, right? If they've asked for the money back, well, let me put it this way. If they've asked for the money back and you've said no, right? Keep in mind they can't unilaterally deduct it from your paycheck, right? They have to get your permission first. That could be something they can discipline you for, right? But if they haven't taken that step of asking you for the money back, they just say, we've overpaid you, you're going to be disciplined. They can't do that, obviously. And Tony, I think part of it is, is it a legitimate overpayment, and what was the reason for the overpayment? And do you have the money anymore? Okay. Because if the overpayment was for, let's say, whatever, $5,000, and you just don't have the $5,000 to pay back anymore in your bank account, no, they cannot discipline you. Okay. That's because it's kind of out of your control. They overpaid you. You spent the money. You didn't know about it. So I would say, Tony, there's more context that matters. And so if you want to provide a bit more specifics about your situation, like how much was the overpayment? Do you have the ability to pay it back? Did they actually ask for the money back? I assume they have, if they're coming to you now. And have they already disciplined you or not? So Jennifer from Facebook is asking, your employment contract says you have to give 1 month of notice to resign. If you give less than a month, are there any penalties or issues I could face? Yeah, good question, Jennifer. So everybody here probably knows about severance, right? You have to give notice of termination. A less commonly known principle is that the employee has to give reasonable notice of termination as well, right? If the employer doesn't provide enough notice, they can get sued. If the employee doesn't get enough notice, they can also be sued. Now, how often an employee gets sued for not giving enough notice? Not very often. It doesn't happen, right? Looks bad on the company, and can they really prove they lost money? So because your employment contract says 1 month, that's the notice you have to give, right? It is a contract. The penalties or issues you could face is if the company can prove they actually suffered financial loss because you left early, right? Because you didn't give that 1 month notice. If they can prove that, there could be issues. The practical reality, whether they actually come after you for it, obviously I don't know the specifics of your situation. I will say in general, it's uncommon that an employer would sue an employee for giving, less notice in their contract. But if you're in a high enough level position and you give a day's notice when you're supposed to give 6 months, the company could suffer financial damages, right? That's something they technically could come after you for. So keep that in mind. Okay. Grace, you're asking if you give 2 weeks notice and you're told not bother to come back. So you've given 2 weeks notice and your employer's told you to not bother coming back. Do you still get paid for the rest of the week, vacation, etc.? So Grace, in general, yes, you do. So we should separate out the different categories actually. So you will get your vacation pay, right? That's just wages you've owed for the work you've done in the last year. And any vacation pay you're supposed to be paid for. Any vacation pay you haven't used. Your wages, right? You're obviously going to get paid for. If you give 2 weeks and the employer says nope, you're gone immediately, that could be construed as a termination, right? A termination of your employment, because, and it depends exactly what they said to you, or what your end date is and all that stuff. But if they're ending your notice period early, they have to give you that balance of the 2 weeks, right? The BC Employment Standards Act makes that very clear. The second question, the second issue that arises is, have they actually terminated your employment, and does that actually get you more than the 2 weeks that you've given, right? So yes, you get the rest. You should get the rest of the 2 weeks. You should get your vacation pay and all that stuff. They can't get away with not paying you that. At least because I'm practicing in BC. I'm licensed in BC. At least in BC, I can say that confidently. Okay, I got a question from Rebel. If you resign from your job, can you take it, or is the decision final? Rebel, if you just want to clarify that question a little bit, what do you mean by can you take it, or are you trying to ask that can you rescind the resignation? If that's your question, I've seen employees, I've seen cases actually where this has gone to court of employees successfully rescinding their resignation, right? And the issues you look at are, was the resignation in the heat of the moment? How soon after the resignation did you rescind it, right? Was it the same day, or was it 6 months later? That makes a big difference. And the third factor courts will look at is, has the employer relied on your decision to resign, right? If you resign and then you don't say anything for 2 weeks and the employer's already hired someone else to replace you, then you cannot rescind it. If you resign in the heat of the moment and you rescind it 12 hours later, right, and the employer really hasn't accepted it or acted to replace you or do anything like that, you can probably rescind. So if you resign, it's not final in all cases. There are numerous cases numerous circumstances where you can rescind and kind of keep working, right? Okay, Tonya, you've got a follow-up. You were asking about the overpayments. You received a bill. They're wanting to do an investigative interview. Doesn't make sense. 8 hours overpayment for holiday pay. So Tonya, I mean, it's if they actually did overpay you 8 hours, right? If that's uncontested, if that's just something that you're not disputing, and you refuse to pay it back, and I don't know why they didn't want an interview, but I mean, you should pay that back, right? That could be disciplinary action against you if you don't pay it back. I don't know why they do want to do an interview. It sounds like there's a dispute whether that's owed or not, or whether there was an overpayment. If there's legit overpayment and they've asked you to pay it back, you have the money in your bank account to pay it back, right? And you don't pay it back. That's something that could warrant discipline. Okay, Rebel. So you were asking if you resign for your job, can you take it back, or is this final? Yeah, so Rebel. Hopefully, I answered your question there. I mean, it depends on, if you want to give me some more info, like why did you resign? Was it were you kind of just having a bad day that day, and you just kind of suddenly decide to quit? How long has it been since the resignation, right? And has the employer said to you, we accept your resignation? So there are circumstances, Rebel, where you can take it back. But if you want to come chat with me privately, and not in this public forum, I'm happy to do so. Okay, so we got another question from Sarah on Facebook. Question from Tony. You're about to go on mat leave. You've been told by your employer that your job will be dissolved by the time you return. And they've given you a new contract to sign for a new position with the same pay but a different title. Can they do this? Yeah, so Tony, or I guess Sarah, you're asking. Sorry, it's a good question, and there's no black and white answer. Okay, I've seen cases where someone goes on mat leave, and there's a mass layoff, and the entire department's eliminated, right? And that position just doesn't exist anymore. And then when they come back, they do their best to find the person who's coming back from mat leave a different job. In that circumstance, the employer is probably allowed to do that, right? Because they're not firing you or terminating you or eliminating your position because you went on mat leave, because that would be sex discrimination. That's different than if you go on mat leave and you've been replaced by someone, right, in the same position, the same title, and you come back and the company tells you, nope, we've replaced you with someone else. You're going to have to go to this other position, right? So somewhere between those two scenarios, there's a line, right, of what a company can do. What the company has to do is they have to prove that this decision to put you in this different job had nothing to do with your mat leave, right? And so companies say a lot of things. They say your job's been dissolved, your department's been restructured, or we've eliminated this team. That might not necessarily turn out to be true. And so to your question of can they do this, it really depends on the circumstances and what the company's actually done, right? If they just restructured your job and just basically split your responsibilities and given it one to Mr. Smith and one to Bob, it's less defensible than if they eliminated like an entire department, right? And so hopefully that answers your question. But in general, I would say that if you can prove that, if you can prove that the change of your position had to do with your maternity leave, the fact that you took mat leave, then the answer would be no, they cannot do that and just put you in a new job. So Brennan asks, what happens if your employer expects you to work after the date they said your termination is effective? Good question, Brennan. Legally, that means your termination date is no longer effective, right? So if you want, you can agree to a new termination date. I don't know if you've done it in your situation, but for example, if your termination date was today and your boss said to you, hey, I need you to come into work next week, right? Then that termination effective today is no longer valid, right? You're still an employee on the same terms and conditions as before, right? Same pay, everything. But how this affects the situation is now they have to give you notice again, right? So let's say you were entitled to 6 months notice before, and the clock started running, let's say March 1st, right? If they ask you to work into next week and there's no new termination date, that means you just go on being an employee, and they're going to have to give you notice again, right? That 6 months notice again, taking you into next year. So, I'd be curious to know if there's a new termination date that you agree to. But if it's just vague and it's out there and they're saying come into work next week, right? The effective date is gone and you're basically an employee. And if they want to terminate you again, then this, more severance or more notice is going to be owed. Okay. So guys, that's all the time I have for today. I will be back in 2 or 3 weeks. I do these every few weeks. My colleague is on tomorrow if I've missed any questions. So please feel free to tune in tomorrow. Otherwise, I hope everybody has a great long weekend. And I'll see you guys in a few weeks.